Good morning and thank you for joining us for our webinar on the Commercial Rent Coronavirus Act 2022 and Commercial Rent Arrears. My name is Seán Hackett. I'm the head of the Myerson Property Litigation Department.
And my name's Laura Pyle and I'm a partner in the Property Litigation Department.
On the 25th of March 2020, the Coronavirus Act 2020 was enacted, which curtailed what landlords of commercial leases could do in respect of arrears of rent, including suspending the right to forfeit. That moratorium comes to an end on the 25th of March, and the Commercial Rent Coronavirus Act 2022 is intended to deal with specific arrears of rent which accrued during the moratorium.
Now I'm going to talk you through your options with regards to the rent arrears that fall within the scope of the Act.
And I will be taking you through your options with regards to the arrears of rent that fall outside of the Act.
So firstly, let's have a look at what arrears of rent fall within the scope of the Act. So, what is the Act and when does it come into force? The Act is expected to come into force on the 25th of March 2022, and it deals with arrears of commercial rent that have accrued during the pandemic in England and Wales. The Act will not apply to all arrears that have accrued, and you'll need to distinguish between those arrears that are within the scope of the Act and those that are not, because the enforcement options to recover the arrears are different. So let's have a look at what arrears fall within the scope of the Act. So, does the Act apply to all tenancies? Well, the answer to that is no. The Act is very specific and does not apply to all commercial tenancies. It only applies to business tenancies that Part 2 of the Landlords and Tenants Act 1954 applies to. So that's where the property comprised in the tenancy is being occupied for the purpose of a business. Tenancies at will and licences, for example, will not fall within the scope of the Act. So does it apply to all rent that fell due over the last 2 years? Well, the answer to that question is also no. The Act only applies to a protected rent debt that accrued during the protected period. So let's have a look at what this means. Well, a protected rent debt is arrears of rent, which includes rent for occupation of the property, service charge, interest, VAT and insurance. The protected period is for arrears that have arisen as a result of the mandatory closure ordered by the government from 2 p.m. on the 21st of March 2020 to 11:55 p.m. on the 18th of July 2021 in England and 2 p.m. on the 21st of March 2020 to 6 a.m. on the 7th of August 2021 in Wales. The protected period ends on the last day the business was subject to a closure requirement within this window. So it's important to note that the protected period will vary from business to business because the closure requirements were different for different sectors. For example, the closure requirements for hospitality and leisure were longer than for other sectors. So this means that the protected period will end on different days for different tenants. For example, some tenants may have a protected period until the 18th of July if their property is in England, whereas others may end in earlier, for example, in April. So how do you know what sectors were impacted as a result of the mandatory closure order? Well, the list of sectors that were impacted as a result of the mandatory closure ordered by the government can be found on the government website. Not all businesses will fall within the scope of the Act, because not all of them were forced to close, and therefore the Act does not apply to everybody. Now, Sean's going to discuss how arrears that fall outside the scope of the Act can be dealt with later. In summary, at the outset, you need to consider whether the arrears fall within the scope of the Act. Therefore, you need to ask the following questions. Firstly, does Part 2 of the Landlords and Tenants Act 1954 apply to the tenancy? Secondly, was the tenant's business subject to a mandatory closure order? And if so, when was the last day the business was subject to a closure requirement? You can then ascertain what the protected period is for that tenant. And thirdly, are there arrears of rent that fall due within the protected period, i.e. from the 21st of March 2020 to the last day that the business was subject to a closure requirement? Now, if the answer to all of those questions is yes, then those arrears fall within the scope of the Act. So, what are the enforcement options for arrears that fall within the scope of the Act? So once you've ascertained whether the arrears fall within the scope of the Act, the question is what steps can be taken to recover those arrears, or as we call it, the protected rent debt. So the first question that every landlord should be asking themselves is whether they want to obtain possession of the premises and forfeit the lease. Now, if the answer to that question is yes, then the landlord can forfeit a lease for breaches other than non-payment of rent, provided there is an express right to do so and the landlord has not waived their right. In addition, if there are arrears of rent that fall outside the scope of the Act, then the landlord will be able to forfeit for those arrears, provided they have a right to do so and have not waived their right. Seán will discuss this point later on. But what's important to note is that a landlord cannot forfeit a lease for a protected rent debt, i.e. for arrears that fall within the scope of the Act. Now, if the landlord does not want to get possession of the property, then what can they do to recover the arrears that fall within the scope of the Act? Now, the Act itself introduces a binding arbitration scheme. So either the landlord or the tenant can refer arrears that fall within the scope of the Act to arbitration within 6 months of the Act coming into force. It should be noted that this period can be extended by the Secretary of State. Now, if neither party refers the matter to arbitration, then the opportunity will have passed and the usual enforcement methods that Seán's going to discuss later will be available to the landlord. But in the meantime, there are limitations on what the landlord can do to recover the arrears. So, the landlord, from the date the Act is passed until the last day the matter could be referred to arbitration, i.e. 6 months from the date the Act comes into force unless that date's extended, or the day the arbitration is concluded, cannot forfeit a lease for non-payment of a protected rent debt, and any steps taken by the landlord, it should be noted, during that period will not amount to a waiver. The landlord also cannot present a winding up or bankruptcy petition against commercial tenants for a protected rent debt. They cannot use the commercial rent arrears recovery scheme. They cannot draw down on a rent deposit, and they cannot issue court proceedings. Therefore, the landlord's options are still very limited. If the landlord does not want to forfeit the lease and simply wants to recover the arrears that fall within the scope of the Act, they can refer the matter to arbitration. They can wait until the period to refer the matter to arbitration passes, at which point they'll be able to use their usual remedies, or they can try to come to an arrangement with the tenant regarding payment of those arrears, and they'll need to make sure that that's carefully documented. So let's have a look at the arbitration process. So where an agreement has not been reached between the landlord and tenant about the payment of the protected rent debt, either party can refer the matter to arbitration. Although guarantors will benefit from any award made, it should be noted that they cannot refer the matter themselves to arbitration. So I'm going to chat to you now about the main stages of the arbitration scheme. So firstly, one party will notify the other of their intention to apply for arbitration. The other party then has 14 days to respond. If a response is received, then the party who started the process has 14 days to consider and respond to it. Either party then can proceed to the arbitration. Alternatively, if a response is not received, either party can refer the matter to arbitration 28 days after the initial notification letter. Now, the party who refers the matter to arbitration has to include a formal proposal for resolving the matter accompanied by supporting evidence. The other party can then put forward a counter-proposal within 14 days that is also to be accompanied by supporting evidence. Either party can submit a revised proposal with supporting evidence within 28 days of their original proposal. Now, the arbitrator must dismiss the case if it's not eligible, but if it is eligible, the arbitrator can accept the referral and make an award. So cases that would not be eligible are where an agreement has already been reached between the parties, or it's not a business tenancy, or there is no protected rent debt and the tenant's business is not viable and would not be even if relief is given. Now, either party can request an oral hearing, and if a hearing takes place, the award must be made within 14 days of the hearing, although that can be extended by the arbitrator or agreement. Otherwise, the arbitrator must make the award as soon as reasonably practicable after the final proposals or time for submitting the final proposals has passed. If the arbitrator determines that the tenant's business is viable, or would be if some relief from payment is given, the arbitrator must consider whether to award relief, and if so, what kind of relief. If one proposal is consistent with the principles of viability and solvency, but the other is not, the arbitrator must make the award set out in the proposal that is consistent. Where neither of the proposals are consistent, then the arbitrator can make the award they consider to be appropriate. Now, the maximum time a tenant can be given to pay the arrears is 2 years. So now let's have a look at some of the practicalities of it. So the Secretary of State will approve one or more bodies to keep a list of arbitrators who are available and suitably qualified or experienced to act as arbitrators. Arbitrators are likely to be insolvency, accounting, or business practitioners, given the focus is on considering the tenant's viability. When assessing the viability of the tenant's business, the arbitrator has to consider the assets and liabilities, previous rental payments made, the impact of the pandemic on the business, and any other appropriate financial information. Now, the arbitrator has to disregard whether the tenant or landlord can borrow money or restructure the business. Now, it should be noted that the arbitrator has to publish the award and their reasons for making it. Confidential information must be excluded from the published award unless the person to whom it relates consents to it being published. In relation to fees, it is the party who refers the matter to arbitration who pays the fee in advance of the arbitration taking place. Any award can be enforced in the same manner as a judgment or order of the court. So what are the practical points you need to take away from this? Well, firstly, if you want to refer the matter to arbitration, it is effectively an accounting exercise, so you'll need your financial departments to assist with the arguments on viability of the tenant's business. Secondly, the timescales for making proposals and responding to the other party under the arbitration scheme are very tight, so you'll need to bear this in mind. Thirdly, there will be a cost to the arbitration and management time involved in dealing with it. Therefore, if you can come to an arrangement with your tenant regarding payment of the arrears, then this may be a better solution. If an agreement has been reached, neither party can use the arbitration scheme. Fourthly, given that the arbitrator has to publish their decision, you may want to consider tactically whether you want it to be dealt with at a hearing. If that is the case, then commercially sensitive information could be heard at the hearing, which could be damaging to one party. And finally, consistency is likely to be a problem. For example, tenants may have multiple properties around the country which may all be dealt with by different arbitrators who come to different decisions about the viability of the business. So in summary, a landlord's options for recovering arrears within the scope of the Act remain limited. The scope of the Act itself is quite limited, and it is necessary to ascertain, firstly, to what arrears the Act applies, secondly, whether a landlord wants to regain possession and forfeit the lease, and thirdly, whether an agreement can be reached with the tenant, and if not, whether the matter should be referred to arbitration within the 6-month window. I'm now going to pass you over to Seán, who's going to talk to you about your options for arrears that fall outside the scope of the Act, i.e. those that fell due before the 21st of March 2020 and after the protected period.
Thank you, Laura. For rent debts which fall before or after the periods that Laura has mentioned, the Act will not apply. Those rent debts are unprotected. It's therefore useful to recap the remedies which are available to landlords for those unprotected debts. And they fall into two categories. One is possession and the other is recovery of the arrears. So let's deal with forfeiture first. Many commercial leases contain an express right for the landlord to forfeit the lease where the tenant is in breach of a covenant in the lease. And in the context of arrears of rent, a breach of a covenant to pay rent on specific dates typically gives rise to a right to forfeit once that rent is in arrears for either 14 or 21 days after it fell due. Even if there's no express right to forfeit for breach of a covenant, a failure to pay rent is a condition, and so a breach of the condition to pay rent will be sufficient. As Laura has explained, the right to forfeit in relation to unpaid rent is currently suspended until the 25th of March 2022, and that is because of the moratorium which was introduced by Section 82.1 of the Coronavirus Act 2020. After the 25th of March 2022, that moratorium ends. Section 82.2 of the Coronavirus Act 2020 specifically stated that during the moratorium, no conduct by or on behalf of a landlord, other than giving an express waiver in writing, is to be regarded as waiving a right of re-entry or forfeiture under a relevant business tenancy for non-payment of rent. So after the 25th of March 2022, a landlord can forfeit a commercial lease for unpaid rent which became due prior to or after the mandatory closure dates that Laura has mentioned. So this will mean that there will be many landlords who will be able to forfeit commercial leases on the 26th of March 2022, the right to forfeit having already arisen but was not capable of being enforced owing to Section 82.1 of the Coronavirus Act of 1820. A landlord can forfeit for non-payment of rent by either re-entering the property demised under the lease, and that's known as peaceable re-entry, or by issuing court proceedings, and there's no need to serve any notices in advance of doing that. Now, for the sake of completeness, the right to forfeit for breaches other than unpaid rent was not suspended under the Coronavirus Act of 2020. Landlords were and are entitled to forfeit leases for such breaches, and a landlord must first ensure that it serves a Section 146 of the Law of Property Act 1925 notice on the tenant, specifying the breach and giving a reasonable time for the tenant to remedy that breach. Only after that time period has elapsed can the landlord forfeit the lease, either by peaceable re-entry or by court proceedings. So pausing there, the key points for landlords are: once the right to forfeit arises, a landlord must make an election on whether to exercise the right to forfeit or waive the right to forfeit. If come the 26th of March 2022, the landlord wishes to exercise a right to forfeit which has arisen, they must ensure that they do not demand or accept the March 2022 quarter after the 25th of March 2022. To do so will amount to a waiver of the right to forfeit, and landlords will want to put rent stops on their accounts and immediately return any rent payments received by the tenant for the March 2022 quarter. A tenant can, of course, apply to the court for relief from forfeiture, and courts will typically grant relief conditional upon the tenant paying the arrears of rent, though it's likely that a court will only require non-ring-fenced arrears to be paid. Though if a tenant can't afford to pay their rent, it's unlikely they'll be able to afford legal fees to go to court seeking relief from forfeiture. Now, given tenants can apply for relief from forfeiture sometimes months after the lease was forfeited, landlords need to be mindful when it comes to granting new leases of the premises to disclose this to the new tenant, because they might find that instead of being able to occupy the premises and quite possibly having carried out fit-out works, upon the grant of relief, the previous tenant goes back into occupation and the premises will need to be reinstated, and the tenant now becomes the old tenant's intermediate landlord. We're going to look now to the recovery of rents. The first one is the Commercial Rent Arrears Recovery, or CRAR. The Coronavirus Act of 2020 currently restricts the use of CRAR. However, this restriction will be lifted on the 25th of March, at which point a landlord can utilise CRAR to recover those debts which are not ring-fenced. CRAR allows landlords to seize tenants' assets at the demised premises to which the rent debt relates to recover the unpaid rent, and I emphasise rent. An enforcement agent must first serve a notice on the tenant. This must be given at least 7 clear days before CRAR is exercised. If the tenant fails to pay the rent in accordance with the notice, the enforcement agent can enter the property and recover goods belonging to the tenant to the value of that unpaid rent. Alternatively, the enforcement agent can enter into what is known as a controlled goods agreement with the tenant, under which the tenant agrees not to dispose of the goods before the debt is paid. Ultimately, the goods can be sold to satisfy that outstanding rent debt. I suppose it's worth remembering that there are subtenants sometimes in place. It's also worth noting that where the landlord has a right to recover rent from a tenant under CRAR, the landlord also has a right to recover the rent from the subtenant, and this might be a useful option if the under tenant is in a better place to pay the rent than the head tenant. Now, a head landlord must serve a notice on the subtenant requiring it to pay the rent directly to the head landlord rather than to its own landlord to the extent of the arrears that are due. Now, if the subtenant fails to comply with the notice, the landlord can exercise CAR against the subtenant. So pausing there, the key points for landlords are, it's important to understand that if a landlord uses CRAR, they will waive any right to forfeit that may have arisen. And CRAR can be used in respect of rents payable for possession and use of the premises. It cannot be used in relation to rates, council tax, service charges, repairs, or insurance, even if those amounts are reserved as rent under the lease. If the landlord charges a fixed rent to include service charge or insurance rent, for example, it's only the annual rent element of the arrears that CRAR relates to. So it's a bit of a forensic work that the landlord might need to do to determine what element of the rent is proper rent. And in order for CRAR to be exercised, there must be at least 7 days of net unpaid rent. And this net unpaid rent must exist both when the notice of enforcement is given and when control of goods is taken pursuant to that notice. Now move to statutory demands and winding up petitions. Now, landlords have been entitled to serve statutory demands throughout the pandemic period. However, restrictions have been in place preventing landlords from presenting winding up petitions in relation to debts which were unpaid due to financial effects of the pandemic. However, those restrictions will be lifted on the 31st of March 2022, allowing landlords to issue winding up petitions in respect of unprotected debts. And I want to say a little bit about rent deposits. And whilst there were no coronavirus-related restrictions on drawing down arrears of rent from a rent deposit, the government's code of practice provided that landlord could not pursue a tenant for a failure to top up a rent deposit. And again, this restriction will be lifted after the 25th of March 2022, meaning that landlords can draw down and require tenants to top up in respect of unprotected debts. In considering a drawdown, landlords should seek advice regarding any notices which should be given to the tenant, and also consider implications of using a rent deposit, particularly where the tenant has entered into some sort of insolvency or that insolvency is anticipated. I'm going to look now at the issue of guarantors. I want to speak first about the former tenant or former guarantor. A landlord should consider whether the unprotected debt can be recovered from a former tenant or guarantor. This option has not been impacted by the coronavirus restrictions, but it's useful to recap its implications. In order to pursue a former tenant or guarantor, a Section 17 notice must be served within 6 months of the rent, debt, or the service charge, or whatever other liquidated sum fell due. This is something I first covered when the Coronavirus Act was passed back in March of 2020. If the notice is not served within the time frame, the landlord will lose its right to pursue the former tenant or the guarantor. If the former tenant or guarantor pays the outstanding sums, they have a right to ask for an overriding lease, which will be inserted between the interest of the landlord and the existing tenant. The existing tenant then becomes a subtenant, and a landlord should therefore only serve a Section 17 notice on the former tenant or guarantor if they're prepared to have them as their tenant. I want to look now at existing guarantors. If the existing tenant's obligations are guaranteed by a third-party guarantor, the landlord could consider pursuing the guarantor if the terms of the guarantee allow. Now, some guarantees only allow the guarantor to pursue that tenant or the guarantor after a specific period, or if the tenant has already been pursued. And the final option is court proceedings. And whilst protected debts will be subject to the arbitration scheme, unprotected debts can be recovered by issuing proceedings in the county court or the high courts. And in many cases relating to unprotected debts, there will be no real prospects of a tenant defending a claim, particularly in relation to principal debts. And in those circumstances, a landlord can make an application for summary judgment of the claim, which allows the claim to be determined, say, within 6 months, rather than proceeding all the way to a full trial. And subject to the value of the debt, the landlord may also be able to recover the cost of the litigation from the tenant. However, landlords should bear in mind that even if they are successful in obtaining a judgment against the tenant, they'll need to enforce that judgment, for example, by way of a charging order in order to secure the sum. And of course, there's no guarantee that at the end of all of that, that the tenant will be able to make payment. So that takes you through all of the options that are shown on the original slide. Of course, if you have any questions in relation to my talk or the matters that were covered by Laura, by all means get in touch with us. You'll see our contact details on the slide, and by all means do access our website and have a look at our commercial rent arrears hub for any useful information and updates. Thank you very much for joining us this morning.